Well, hello, my name is Jim Parodic. I'm here to introduce the CLE that is being put on this week, sponsored by the Law School's Board of Advisors and Academic Engagement Committee. The CLA today is What's in the Works, Developments from the Front Lines of American Labor Law. And just a quick kind of couple of housekeeping notes. Today's webinar is being recorded, and the link to the recording will be shared live to all of you following the event. We have also live auto captioning enabled, so you can click on the live transcript feature at the bottom of the Zoom to view or hide these captions throughout today's discussion. And we're also going to be, I'm going to be here present during this just to field Q&A. Questions might be in the Q&A, and then either kind of wait to the end to ask them of the panelists or try and intersperse as appropriate. So please, if you have questions, shoot them in there, and I'll try and get them asked of our panelists. One goal that we have in the Academic Engagement Committee is especially in the Spring Alumni Week, is to both have something that's of broad topical interest to people that are engaged in the law, and this certainly fits that description, we think, and also just to showcase just the dynamite academic horsepower we have at the University of Minnesota, especially some of the newer professors. In one area where the law school has been really strategic is getting on board these two really talented and exciting labor professors, although they do other things too, as you'll hear. So I think you're in for a treat today. Just very quickly to introduce our two panelists. Professor Charlotte Garden is a professor at the U who specializes in labor and employment law and constitutional law. Her work includes law review articles and book chapters, and she's a co-author of casebooks on labor and employment law and co-editor of the Cambridge Handbook of Labor Law for the 21st Century. She frequently co-authors amicus briefs and has been active in national policy efforts to strengthen workers' rights, including testifying before Congress in support of the Protecting the Right to Organize Act, the PRO Act. I didn't realize this, Professor, but you're a SCOTUS blog contributor, and I have appreciated your really educational and accessible articles on SCOTUS blog about some of these more important recent developments in labor law. So thank you for that. Also, I know you were a practitioner in Washington, D.C. as a labor lawyer before you began, or somewhere in the process of your career you were. So, and then also with Professor Garden is Professor Matthew Bodie. By the way, Professor Garden is Julius E. Davis Professor of Law. Professor Bodie is Robbins Kaplan Professor of Law. Professor Bodie teaches and writes on labor law and employment law, corporate law, data privacy, and algorithmic management. He has published over 70 book chapters, articles, and essays, including serving as reporter for the ALI's Restatement of Employment Law and co-author of Labor Law Treatise for Foundation Press's Concepts and Insights series. You can find his articles in New York Times, Wall Street Journal, or he's at least been quoted in those, especially on the topics of the Starbucks union organizing drive, employer surveillance, and workplace challenges during the COVID-19 pandemic. And I know I was just talking to Professor Bodie. He was an NLRB lawyer in the course of his career and has represented, and he's worked on a number of cases on the ground, including National Hockey League, construction law firms, and apparently a Chinese banquet hall, which sounds intriguing, but we'll probably talk about that some other day. So it's with great pleasure I turn the reins over to you two.
Yeah, great. Thank you so much. And thank you for that introduction. So let me jump in by asking Matt about sort of some of the high profile strikes and organizing campaigns from this year. So, the last couple of years have seen some, just really sort of significant strikes. I think a lot of people are sort of following and interested in union drives at like Starbucks and Amazon and Trader Joe's. What has kind of stood out to you as some of the most interesting of that set?
Right. So first of all, thanks so much to Jim for moderating and for that great introduction. Hello to all the alums and practitioners out there, and hello to my labor law students, some of whom might be tuning in. This has really been an extraordinary time for labor and labor law. I started the NLRB in the late 90s, and I haven't really seen anything like this, any period of time where we've had such sustained engagement with labor, such successful organizing drives at such a big scale, and in traditional areas that had not been unionized, and then successful strikes. We've certainly seen those in the past, but to have them all kind of clump together has been really kind of extraordinary. So just kind of a brief word about some of those. So we had the Hollywood strikes, right? The WGA and the SAG-AFTRA strike lasted, I think the WGA was 146 days. The SAG-AFTRA was 118 days. It kind of came after the writers were the first to go. The directors kind of signed on, they didn't strike. And then the writers were the first to strike, and then the actors followed soon thereafter. And we have some potential negotiations coming up with other Hollywood unions. We're going to see how that all shakes out this year. But I think most observers would say that those strikes ended successfully for the unions. Of course, there's some debate about how successful they were, but certainly there were pay increases that were more than the studios were offering at the beginning. There have been significant streaming rights that have been added, right, to pay bonuses that were not available before. The constant push of the writers and the actors is to continue to be involved in the generation of income for their work for years to come, right? As way back, in the early part of the 20th century, the writers were pushing not for just a one-time payment, but for the right to residuals, right? Same thing with actors. And that's kind of what the unions have continued to push, and they've been largely successful. And of course, that brings up AI, right? Can in the Writers Guild, can companies turn to AI to generate screenplays? Can they create a version of the character using AI and use that kind of going forward, even though it was started by a particular human actor? So these are things that the union was able to put some sort of guardrails around and limit those abilities. But we've seen some real significant efforts by unions to make sure that they are getting some sort of handle over the ability of the studios to use those sorts of things. Just briefly, in terms of the UAW strikes, very successful set of strikes, kind of an innovative strategy of not going completely on strike, but targeting particular plants, and doing all three at the same time, not one particular company, but all the big three. I think most people would say, again, there's some individual plants where the members did not support the overall contract, but I think overall most people think that was a very successful strike for the union, that they got a lot of pay increases, and it's really generated a lot of momentum. We see upcoming votes at Mercedes and Volkswagen, where there have been efforts at Volkswagen in the past that have not been successful, but people seem to think this time around might be different. Of course, we'll have to wait for the votes to see. And then finally, we've seen some of the healthcare strikes locally, with 15,000 nurses going out on strike. And again, not getting everything they wanted, but getting substantial pay increases and getting some more control over staffing decisions that they were looking for.
And so I wanted to kind of pick up on a couple of things you said. I mean, one, the success of the UAW strike kind of rolling into an organizing campaign, right? So if the UAW sort of put out this commercial saying like, hey, here's what we got at the big three. That's not what you're getting at your workplace. Let's talk. The UAW has sort of tried a number of times over the past several decades to sort of gain a foothold at auto plants in the southeastern US. It's never succeeded, right? Question is this time different? Is this the moment? Both coming after on the heels of the successful, strike of the big three, and then also, it's obviously just a moment where there's a lot of kind of excitement for labor organizing, and we're seeing, these kind of like landslide union elections in contexts like higher ed, to name one. What about Starbucks? Should we talk about Starbucks a little bit?
Sure.
Starbucks, at this point, there are, 300 or 400 unionized Starbucks stores. For a long period of time, I thought, there will never be a contract, right? Because the company seems just utterly unwilling to kind of come to, to come to an agreement with an individual store, and potentially kind of create the sort of demonstration effect. But recently, right? Recently, there was this announcement of movement towards a framework agreement, and some other concessions, right? So potentially that Starbucks would withdraw some pending litigation, potentially that, and that Starbucks would give certain improvements in employment and working conditions to stores that had unionized, which it had previously refused to do. Are you optimistic about those developments?
Well, that's a dangerous question, optimism, right? I feel like as labor law professors who are interested in collective bargaining. So that was one thing that my regional director, Dan Silverman, told me at the board, is that the board is not pro-union, it's not pro-employer, but it is pro-collective bargaining, because that's the purpose of the act, is to facilitate collective bargaining. So as someone who thinks collective bargaining is an important tool for workers to be able to choose in certain circumstances, optimism has been dangerous given the kind of continuing fewer and fewer workers who have chosen that option at private sector employers. So I do think, given the reactions of the participants, again, we're kind of there's still this kind of cloud of uncertainty, framework agreement, but not a lot of details. Obviously, some of the litigation is continuing to go forward. It's not like Starbucks has dropped all its litigation, as we'll talk about in just a second. But at the same time, I think the participants, particularly the union, seems to be optimistic. It is something that if Starbucks are continuing to dig in its heels, I think that would be something that they could do, right? And as you mentioned, the playbook up to this point has been stall, fight. Do not ever agree to a collective bargaining agreement. And there's no requirement under the NLRA that you agree to a collective bargaining agreement. You have to bargain in good faith, right? So there might be allegations and findings, ultimately legal conclusions of bad faith bargaining, but it looked like there was going to be a stonewall about ever agreeing, and that's something that has happened in the past at companies like Whole Foods, where there's the Madison, Wisconsin. Whole Foods was once organized, but the company never agreed to a collective bargaining agreement. Eventually, the union disappeared. So, I am hopeful, and I certainly think that, given the over 400 stores and continuing, right? It's week after week, we see more and more stores organizing. Hopefully, there will be some movement there to actually come up with real ways of changing individual workers' terms and conditions of employment.
Yeah, so you brought up 10J.
Yes. So let me hand things over to you to talk a little bit about this case, of which you've co-authored a amicus brief for the Supreme Court. You can find it handily on SCOTUS blog, for example.
Yeah.
Along with a lot of other great commentary from folks like Professor Garden. But so anytime you have a Supreme Court case, it's a big deal, right? And so this is a case involving the standard to use in injunctive cases, and the particular case involves the Memphis 7, a group of 7 workers at a Memphis Starbucks who were fired during the organizing campaign. So tell us a little bit about this case, and what do you think about the ramifications for this case, for not only Starbucks and the union, but also for labor law more generally?
Yeah, so this case is about 10J of the NLRA. It's a provision that was added to the National Labor Relations Act in 1947 at a time when Congress was really worried about the effects of unfair labor practices, particularly union unfair labor practices. So in particular, Congress was concerned that unfair labor practices might sort of unfold and kind of have their desired effect in a way that was effectively impossible to remedy. So, Congress sort of says, okay, what we're going to do about this is give the NLRB the authority to go to a district court and seek an injunction to restore or to hold steady the kind of status quo. So what happens in a 10J case is, a charge comes in, it gets investigated by, lawyers who are kind of under the auspices of the board's general counsel, which is the board's prosecutor. If they decide the case is potentially appropriate for 10J relief, so they decide this is a case where there are facts that sort of support going forward at all with this case, and also it's the kind of case where we're worried about the ability to remedy the effect of the unfair labor practice kind of effectively after the fact, then there's a kind of process to get approval that involves the board itself, sort of saying, okay, we agree with your assessment or we don't. If we agree, then you get to go ahead to the district court and ask for a 10J injunction. This case is really about what happens then. So the district court in this case, and then the Sixth Circuit, which affirmed the district court, considered roughly the factors I just described. So they considered, is there a reason to believe that the general counsel is going to be able to, has the general counsel made kind of a reasonable showing that the board will eventually find an unfair labor practice has occurred? And also, is there a need for the injunction, right? Is there the kind of fact pattern that suggests difficulty remedying the ULP later? Like you mentioned, this case involves, 7 workers who were fired from a Starbucks in Memphis. And in cases like this, I think the board is worried about, partially the effect on the workers themselves, right? The workers are fired, often low-wage workers. It can be years before the case is completed and they would potentially get back pay. But the board, I think, is also worried about the effect on the organizing campaign itself. If an organizing campaign is partially kind of about momentum, then firing workers because of their organizing, right? If that's what happened, of course, Starbucks says that is not what happened. But firing workers because of their organizing would really put a kind of damper on the organizing campaign, and you can't kind of recapture that momentum, 2 years later when the case is over. So the Sixth Circuit, agreed with the district court that the injunction was proper. But one of the panel judges, Judge Riedler, wrote a concurrence saying, this isn't the way we should be deciding these cases. What we should be doing instead is applying the kind of 4-factor kind of familiar formula that applies in injunctions sought by private parties and just kind of any, kind of normal litigation, called the winter factors in this case. So Judge Riedler said, look, injunctions ought to be granted only rarely. There ought to be, a more compelling, sort of showing of, on the facts, more compelling showing of irreparable harm. The court ought to sort of consider the public interest for itself. All the things that would happen if this were kind of a standard lawsuit, right? Where a court was considering an injunction. So that's the issue, right? The issue is it appropriate to apply this kind of 2-factor framework? Some circuit courts sort of do something that involves 4 factors, but they apply the 4 factors in a way that is fairly similar to what the Sixth Circuit did, just kind of asking, is the board being reasonable? Has it shown it needs the injunction? Or should it do what it would do in kind of other cases, in kind of private party cases? So with a co-author, Sachin Pandya at the University of Connecticut, we argue that when Congress added 10J to the act, it did so against the backdrop of both Supreme Court cases and other statutes that allowed kind of statutory injunctions, right? The idea being that the cases like this are different than kind of normal private party cases, because these cases involve an agency that is responsible for enforcing the law and that ultimately will find the facts in the first instance. And where that is the case, right, where the agency has done some investigation, decided this is appropriate as an exercise of kind of its prosecutorial discretion, that it would not make sense to kind of demand the same type of showing as you would ask it for in kind of a standard case. We have, sort of various other arguments about kind of labor history and the history of injunctions in labor cases going back before the 1930s, which if anybody is interested in, I would love to, talk to you about at great length. But but those are the kind of nuts and bolts. And so it really is about the board's ability to get these injunctions. The last thing I would say about that is 10J injunctions are relatively rare. So, the board pursues them somewhat more often now than it used to, but we're still talking about like 20 cases a year. So we're talking about, an unusual situation where the board decides it's appropriate to seek this kind of injunctive relief.
Yeah, and interestingly, at least early on, the board was not using a lot of 10J. I think it might have come up more recently. But in terms of the Biden administration, it was fairly robust during the Obama administration, then it went kind of down pretty sharply under the Trump administration. And Biden administration went up a little bit, but so yeah, we're talking at most, right? If you're talking about a really aggressive board, you're talking about less than 80 cases a year. I think might be the maximum at one point. Maybe it was 100, but a very small number. I think in some ways it says more about kind of the relationship between the board and the courts, what the court says in terms of how the board has been proceeding. I also think without the framework agreement, it could have had more of a symbolic, because if the union had lost in the Supreme Court, right, and they're still like, not getting anywhere with the with Starbucks and bargaining, that might have been, kind of hard rhetorical hit to take, even though I think ultimately, I mean, the 7 have been put back to work. It's not like they're going to be refired or something like that. Oh, we don't have to hire you back. Let's fire you again, right? So in this particular case, a big practical impact, but it certainly is a pretty big 10 junction case, a pretty well-known 10J case to have chosen.
Yeah, so speaking of high-profile board decisions, so, I tend to think one of the Biden board's most significant decisions is this case called Cemex, although I'm not totally sure that's how you say the employer's name. It has to do with the employer's obligations when a group of employees come forward and say, a majority of us want union representation. How does Cemex change things? Why is it such a big deal?
Right. Yeah, it's funny you say that, because I was teaching that case and I'm like, how do you say it, Cemex or Cemex? So like they're different. I looked at YouTube and different people were saying, and then there was a board one that said Cemex, so that's what I'm going to go with. I assume the board was right, maybe not. Apologies to Cemex if that's how you say it, but Cemex. So there's this old doctrine called Joy Silk, which for labor law nerds is like really like, it's the chef's kiss of, old labor law doctrines that labor law nerds are into. And a really interesting paper by Brandon Magner, who's now at the Indianapolis regional office of the board. Shout out to him. He kind of revived discussion of this idea. And the idea behind Joy Silk was that rather than the employer automatically getting the right to request a secret ballot election, if the employees came to the employer and said, hey, look, we want to be represented by this union. In fact, a majority of us have signed up, right? You only need 30% of the unit to sign up in order to get an election, but let's say you have an actual majority, right? In theory, the employer could recognize that group and say, we recognize your union and we'll begin bargaining. But the rule has been that the employer could say, no, if you want to be represented, you have to petition the NLRB for an election, and we'll go from there. When the board will come, they'll hold a secret ballot election, and then we'll go from there, right? So The Joyce Silk had originally said, well, the employer doesn't have a right to ask for an election. And in fact, it has to have good faith doubt as to the majority status. And if it doesn't have that good faith doubt, then it's an unfair labor practice for it to fail to bargain with the union upon majority showing. So I think CEMEX is something of, it's closer to Joyce Silk, but it doesn't necessarily go all the way back to that, because essentially I think two main things have changed. One is the board has said if a majority of employees present, or if the union presents evidence of a majority of employees supporting the union, it's now up to the employer, if the employer doesn't think that, actual majority really represents the union, or really wants the union to represent them, sorry. The employer now has to go out of its way to file a petition. The employer has to call the board into it and say, all right, we are seeing here that the union purports to have a majority, so we want an election. So if the employer fails to do that, then if it then fails to bargain with the union, it will be in violation of the act. The other change, which I think is a substantial one, although it kind of has ties to the old Gissel case, or at least echoes of the old Gissel case, is that if the employer conducts any unfair labor practices after the filing of the petition or after the presentation of the majority of cards showing union support, between that time and the time of the election, if the employer engages in unfair labor practices, essentially the board will say, you don't get your election, you are in violation for failing to recognize the union, and we'll proceed from there. We'll impose a bargaining order on you, which is the traditional Gissel bargaining order. So the Gissel bargaining order has always been there for situations where employers conduct a pervasive and severe campaign. The actual opinion was pervasive or severe, I believe, but it's been kind of read by the circuit courts as pervasive and severe. When the employer commits a lot of really damaging unfair labor practices, then the board will often impose a bargaining order rather than ordering a rerun of the election. But under CEMEX, the idea, I think, is that there's more of a hair trigger for any unfair labor practices. What do you think? Do you think that's a fair reading of the opinion?
Yeah, I do. Yeah, I mean, it's interesting to see CEMEX start to play out. In particular, that employers, first of all, they're filing a lot more petitions. So, the kind of latest statistics are, a couple hundred employer filed petitions for election. And that's new, right? I think it used to be much more rare for employers to file election petitions. And then also in cases where a petition has been filed by either the union or the employer, and then some kind of unfair labor practice takes place, right, that we're seeing settlement agreements that include the imposition of a bargaining order and bargaining obligation. So it seems like employers are certainly not embracing CEMEX, but, sort of saying like, okay, if there's a kind of plausible allegation of an unfair labor practice that's occurred after the filing of a petition, that may lead to imposition of a bargaining order. Whereas, my sense was that the Gissel bargaining orders that you were talking about a second ago would often be sort of easier to fight, and therefore employers would be less willing to agree to them in the settlement process, in part because the board, but also the circuit courts would say, after some period of time has gone by, the effect of the unfair labor practice has kind of dissipated. So, the CEMEX court seems a little more skeptical of that idea.
Oh, that's really interesting. That's really interesting. Let's turn to another big board decision, which is the board's decision that it was an unfair labor practice for an employer, in this case, it was Home Depot, located outside here in Minnesota, right outside Minneapolis, I believe. The board found that the employer had violated 8A1, committed an unfair labor practice by disciplining an employee for wearing a Black Lives Matter insignia, BLM insignia. Maybe you could tell us a little bit about what was the nature of the charge, and whether you think there's been any change in board laws as a result of this decision.
Yeah. So in case people on the call are not kind of NLRA aficionados, which frankly I would find hard to believe, but on the off chance, let me sort of talk a little bit about sort of what an 8A1 kind of unfair labor practice even is. So the kind of heart of the National Labor Relations Act is Section 7. Section 7 protects employees' abilities to engage in concerted activity for mutual aid or protection. You can kind of break that into two pieces. Concerted activity, so there has to be more than one of you. That doesn't mean that everything you do that occurs in the course of some kind of, either union organizing campaign or attempt to pressure an employer to change something about your working conditions. It doesn't mean you have to do everything in lockstep with somebody else, but in general, there has to be, more than one employee who's interested in, or at least might potentially become interested in, doing the thing that you're doing with you or achieving the result that you're trying to achieve. It's a concertedness requirement. And then there's also, okay, what counts as being for mutual aid or protection? So that's the kind of idea that the National Labor Relations Act covers collective action about working conditions. So, something that is, an attempt by multiple employees to pressure an employer to do something that's totally unrelated to work, that wouldn't count as for mutual aid or protection. That said, the court has interpreted the idea of what counts as for mutual aid or protection relatively broadly. The key case here is a case called the E-Stex that involved employees who were circulating a kind of union newsletter. The union newsletter talked about some kind of local, kind of statewide and the occasional kind of federal political issue that related to working conditions. These were not these kind of legislative initiatives wouldn't kind of directly help the employees who were engaging in circulating the newsletter. The employees, the Supreme Court ended up saying that doesn't matter, right? The baseline set of employment protections that exist for all workers relates to what any group of workers can sort of get at the bargaining table. So if employees who themselves make more than the minimum wage engage in concerted activity related to sort of setting or raising the minimum wage, that's still related to working conditions, right? That still falls within the scope of the act. So those are kind of the two requirements. And then the third thing in the background is that concerted activity can lose the act's protection under certain circumstances. So if the concerted activity is disloyal in the sense that it sort of disparages the employer's product and nobody can tell that the speech that the employees are engaging in is related to their own working conditions or related to union activity, that can be a reason that you would lose the act's protection. Speech can be sort of too opprobrious, the board's word, and therefore lose the act's protection. So there's like a set of principles there also in the background. So that's kind of the background. So here, this is one of a number of cases that are pending sort of around the country in various stages, raising fact patterns where one or more employees has written like Black Lives Matter on their uniform, or they've worn a mask that says Black Lives Matter, and the employer has sort of asked them not to. In this case, the question that the board was like the harder question for the board was whether the employee acted concertedly, right, acted with other employees when he wrote BLM on his apron. A couple things, right? So one thing you might be wondering is like, oh, was he fired because he wrote on his apron without regard to what he wrote? The answer there, no. Apparently Home Depot encourages people to kind of make their aprons their own. If you are a fan of the movie Office Space, it's very like 30 pieces of flair, right? Like, so the idea is, so that wasn't the issue. Also, the issue of for mutual aid or protection wasn't really on the table. Unlike in some other cases that are pending, this wasn't a situation where the employees were saying like racism in broader society affects us, perhaps at work, perhaps not. And so we want to kind of wear this message. This was a case where the employee wrote BLM on his apron, like specifically because of like ongoing issues about race and racism in their specific workplace. So these employees have been engaging in various kinds of advocacy related to like a series of events that have been taking place in their specific workplace. So really the issue was just concertedness, right? So the board was deciding, you know, ultimately a couple of employees like wrote the same message on their aprons. It arose out of this other advocacy that had been happening at the workplace that was definitely concerted. Board ended up saying it's fairly easy to say that even if the employees sort of didn't get together and say, as a group, we're all going to write Black Lives Matter on our aprons, it's still concerted activity. It's related to kind of unquestionably concerted activity for mutual aid or protection. So that actually makes this case more straightforward than many of the other cases that are pending, right? So many of the other cases are presenting this issue of like, what kind of nexus to working conditions do you need? Is it enough for an employee to say, you know, like racism in this city affects me when I'm traveling to work? Or does it have to be something that is more within the specific employer's control? So, you know, I expect that we'll see, you know, we'll start to see board decisions and ultimately circuit court decisions in those other cases, you know, rolling out, right? This one was, you know, it's interesting because it's close to home and to my knowledge, the first time the board has sort of decided one of these Black Lives Matter cases, but it was also like a considerably more straightforward case than some of the others.
Right. Yeah, just to echo that. Yeah, I think it was a supervisor who had allegedly said some things that could be perceived as prejudiced or biased. I'm taking some actions. So yeah, no, I think it's a really interesting issue. To what extent? Because we're seeing unions and groups of employees take on kind of bigger societal issues here. With the Wayfair employers, this was back during the Trump administration, the employees didn't want the company to be working with ICE for detention centers and providing furniture for that. You've seen other employees being upset that their tech work is being used for satellite systems or other instruments that potentially could be used in war. This is a huge issue, and the other thing is it doesn't apply just to unionized employees, right? A lot of people think unions and labor law are kind of a overlapping circle, and obviously labor law has a lot to do with unions and collective bargaining, but this is something that could pop up for any employer, right? The right and a lot of employers, you know, whenever you hear an employer say you can't talk about your salary amongst yourselves, right? You can't share your salary with your coworkers. That's an unfair labor practice under federal law. So and there's no need for any union to be at that workplace. So this is an issue that I think is really going to be important going forward. And it is kind of interesting that the board did take pains, I think, to say we're not talking about the substance as much as we are, like you said, the concerted nature of the activity.
Can I ask you a quick question along that line? So that's something that I hadn't fully appreciated. So is it an individual right potentially of a worker by themselves to invoke some of these rights, or does it have to be through a mechanism, more associational mechanism? I'm not a labor law nerd at all, obviously. So I'm just wondering about that.
Yeah, I mean, there's a category of hard cases that are about an employee who is trying to generate collective action, but it hasn't happened yet, right? So if an employee says to a group of their coworkers, like, hey, let's not stand for this, let's all go, you know, file a petition or talk to the boss or whatever, let's all go do this together. Like that's inviting collective action. And there are certainly boards that have said, yes, we recognize that as fully protected activity, even if the other employees don't kind of go along. The theory being like, look, if collective action is going to kind of get off the ground, it needs to be protected from the moment somebody tries to bring it about. There was a case decided under the Trump board that sort of took a narrow review of things. It was a SkyCap who was going to was asked to carry the baggage of a soccer team that he thought wouldn't tip well, and said, didn't quite say, let's strike, but said something a little to kind of fellow SkyCaps that was a little bit more like, this is, I'm not remembering the precise sentence, but said something along the lines of like, this is like, this bad, this is not going to work, or something like that. Trump board said that wasn't concerted. It wasn't clearly directed at like embarking on some kind of concerted activity. But Biden board, I think, would be more open to the idea that that was concerted.
Yeah, no, I think that's exactly right. And so that's that reaching out to other employees that matters. You can like a Facebook post, and that can be concerted, right? Because if the Facebook post says, hey, boy, the supervisor's really been terrible lately, I'm really upset about it, and you like that, right? That can be protected.
Yeah, so while we're talking about things that might happen, or like what you're kind of waiting for the board to decide, what are you thinking of as sort of the kind of most interesting things to watch out for?
Well, we haven't talked about the constitutional challenges, and I'm going to defer to you. Maybe I'll set that up, but I teach contracts, so I'm just a humble contracts and labor law lawyer. This kind of heady constitutional stuff, I kind of thought, okay, yeah, whatever. A couple companies like SpaceX took the lead in challenging the constitutionality of the NLRB. I know my, Jones and Laughlin Steel, I know the switch in time that saved 9, you figured like all this was behind us on some level. But there are, I think, a few different kind of claims that these companies, and they, a number of companies have added their names too. And Trader Joe's is one, for example. And these are companies that are not known for like taking radical stands against government regulation. So kind of interesting. I think their lawyers just think they're preserving the argument, but at least publicly, they've been kind of called to account for, hey, why are you saying that the NLRB is unconstitutional by some of their constituents and some of the unions that are looking to represent or are representing their employees? So basically, there's a challenge to the institutional structure of the board and the relationship between the president and the members of the board. And then there's also a challenge to whether the board is protecting private rights and whether, if those are private rights, they need to, under the 7th Amendment, be afforded the right to have a jury trial. I really don't want to wander too much farther down that road. Maybe if you have some further thoughts about the challenges themselves.
Yeah, sure. So so I agree that I agree with your suggestion that the companies may be thinking of themselves as just preserving these arguments, because the arguments they're making are also pending before the Supreme Court in a case called Jarkissi, which involves the SEC. And so one way to think about this is like, well, they're waiting to see what happens there, and if Jarkissi opens up space to make an argument in the board context, well, they'll be set to do that. They're also, the arguments in Jarkissi were successful before the Fifth Circuit. So the other thing that's going on, particularly in the SpaceX case, is the employer fighting very hard to get into the Fifth Circuit instead of in the Ninth Circuit. And there's currently a sort of a tussle between district courts and the Fifth Circuit about where this case will be heard. But yeah, so there are a couple of arguments about whether the NLRA improperly insulates either ALJs or the board members themselves from removal at the president's discretion. And then there is also the Seventh Amendment jury trial argument that relates to that relates to situations where the board is seeking kind of, if you like, unusual remedies. So it's long been the case that the board would seek, reinstatement, for example, and back pay. In a recent case, the board said, we're also going to issue orders saying that, if employees who, are kind of like the victims of an unfair labor practice have had kind of downstream costs, right? Medical expenses they incurred because they lost their insurance, for example, that those could also be assessed against the employer. So the argument is that those kind of downstream costs would have to be assessed in the context of a jury trial. And then the last kind of argument is that it actually goes back to 10J again. The argument is that 10J involves a combining of executive and prosecutorial functions by inviting the board, which will ultimately decide an unfair labor practice case, to authorize seeking the 10J injunction. So the argument is that that involves an impermissible kind of combination of powers. So, I could imagine, right, the court saying based on some cases decided in kind of similar context before. Like I can imagine the court saying that, it agrees about like the ALJ argument, for example. But the question is what happens next, right? So even if the court says, that both the ALJs and the board members are improperly insulated from removal by the president, one thing that could happen next would be that, okay, so now the president can remove them at will, and everything else continues as normal, right? Return to your regularly scheduled programming. What's really sort of significant about the employer's argument here is they're saying, no, the whole statute gets struck down. So the board can't hear unfair labor practices at all, right? If it argues, if the court agrees. That, I think, that strikes me as very unlikely, right? That strikes me as unlikely to succeed. But you should ask me again after Jarkissi comes down.
Right. Yeah, so we're kind of in a holding pattern. I think somewhat surprisingly find ourselves here, right? Again, because I think, and I think some of, like you're saying, some of the changes would be more of a change to the structure of the board than others, right? And certainly the board has had issues before. With the quorum requirement, when there were only 2 board members, the Supreme Court said you can't do that. When the Obama administration appointed a board member during what looked like a congressional or a Senate recess, but the Senate hadn't declared it to be a recess, the court said you can't do that. So we've had kind of issues with the structure before, but I think some of these could be more substantial, particularly the jury trial one. I think I don't know. Again, I'm not going to hazard a guess because it's not my area of expertise, certainly, but at least in terms of what that could do, right? If you did have a jury trial requirement in the context of the board, that would really, I think, dramatically change the way the board proceeds on a day-to-day basis.
Yeah, that doesn't strike me as a tremendously likely argument to succeed. I mean, usually the court would ask about sort of whether the statutory scheme vindicates a right that is closely analogous to a right that previously existed at common law, which is quite a different question than like what are the specific remedies that are available. So that strikes me as a significant reach. But yeah, I guess we'll see. We'll see, right? We'll see what happens after Jarkissi. So you teach contracts, and it seems like one interesting thing the board is doing, or at least the general counsel is encouraging the board to do, is look more closely at certain kinds of contracts that employers ask employees to agree to. So I'm thinking about non-competes. I'm thinking about severance agreements. Yeah, are you watching these cases closely?
Yeah, so we've had a lot of action here from the Federal Trade Commission too, right? The FTC is looking to enter into this space as well. We've seen more interest in labor and antitrust, and whenever you talk about non-competes, that's something where this kind of combination and restraint of trade comes in. Again, obviously, there's a labor exemption for collective bargaining more generally, but when employers are combining without the protection of a multi-employer bargaining structure, right, we have to get worried. And also when we're looking at individual employees, again, we've talked a little bit already about how the act can apply in the context of individual non-unionized employees. This is another area where I think the board is looking at, the ability of companies to impose things that might restrict employees' ability to act concertedly, right? Either make efforts to reach out or otherwise. And so certainly a lot of what has been going on in this space for a long time has been situations where the company is trying to restrain employees' ability to engage with other companies, engage with other workers. I wonder, right, the further the board goes into these areas, you do worry about some potential for conflict with other agencies. Now, again, if the FTC is working along the same lines as the board, that might be an area that of synergy rather than conflict. But when the board went down this line with regard to arbitration agreements, ultimately it hit the backstop of the Federal Arbitration Act, and the court struck down the board's approach in saying that those were violations of the act. So what do you think? Do you think this is something that the board will be active and successful in changing the way employers go about structuring these types of clauses?
Yeah, so, I mean, I think there's this general counsel memo saying that the general counsel believes that non-compete agreements can interfere with employees' rights under Section 7 of the Act, because a non-compete agreement would mean that an employee would sort of know, like, oh, if I lose my job, if other employees and I all sort of quit our jobs, right, if we sort of engage in mass resignation, that will mean that we can't continue to work in our area, at least without, sort of moving far away. So the general counsel is really focused on how those agreements would chill Section 7 activity. Remains to be seen whether the general counsel will find like a sort of good vehicle to, bring that issue before the board and have the board decide it. But I also think it's really interesting. So another kind of recent board decision, a case called McLaren-McComb, saw the board say that when an employer offers an employee a severance agreement that requires the waiver of NLRA rights, that violates the act. So it had already been true, so the Trump board had adopted a narrower version of that said if an employer sort of very coercively offers a severance agreement that involves waiver of Section 7 rights, that could, under kind of narrow circumstances, that could be a violation of the act. This board said, we think the fact of sort of the conditions that inherently exist when somebody is being offered a severance agreement are enough to prevent them from being able to kind of exercise free choice about their Section 7 rights. And so said, a severance agreement that says, you can't talk about your work here. You can't sort of engage in other, you can't sort of make reports about working conditions that you want to change or sort of work with existing employees, that those terms would violate the act in the context of a severance agreement. So I was surprised. So I will say I was sort of somewhat surprised to see the board sort of take that approach, mainly because of sort of what you were describing, right? The sort of sense that that a severance agreement is a common, right, it is sort of common strategy that employers use, that, courts don't necessarily engage in too much scrutiny about. But on the other hand, there is longstanding board law that an employee doesn't lose their Section 7 rights just because they've lost their job. And so in that sense, right, an employer sort of saying, I'm incentivizing you in an environment where you don't have many options to waive your Section 7 rights, right? To agree to waive them prospectively. That starts to sort of make more sense and kind of fall in line with existing board law.
Right. And I think you also bring up an example of which we've seen a couple already, right? Of the general counsel maybe pushing for changes in the law that go beyond what either the board has gotten to yet, because we're still waiting for some of the cases, or before more than the board wants to give at any particular moment, right? I think the general counsel was looking for maybe a broader statement about political speech in the context of employee statements on uniforms and the like, buttons, on the apron, the Black Lives Matter case. The Cemex case, the GC was pushing for something that was closer to a Joy Silk approach that would have put more of the onus on the employer to recognize the union if there was a majority. We've seen things like surveillance. The general counsel had a very broad memo kind of calling into question even kind of seemingly new. So it's long been the rule, just to back up a second, it's long been the rule that surveillance of protected activities, surveillance of union activities is a violation. At the same time, we know that Amazon just records everything kind of in their facilities, and the general counsel says that could be a violation of labor law. She's pushed to make all captive audience meetings a violation of labor law, rather than just the 24-hour rule that we've had in place for a long time. She's pushing for student athletes to be covered, and we've seen that in the Dartmouth basketball case, where a group of athletes were deemed to be employees under the act by the regional director and have had an election and have voted in a union. So there has been a lot of change that this general counsel has really been fomenting.
Yeah, on the captive audience meeting point, well, first of all, I mean, Cemex actually presented that issue. So, I think the general counsel was probably hoping that the board would sort of take that opportunity to change the rule there. But also, a number of states, including Minnesota, have adopted statutes saying that employers can't fire employees for refusing to attend meetings where religious or political matters are discussed, right? So the idea is to kind of establish as a baseline that an employer can have, an optional meeting about political or religious matters, but can't compel employee attendance. And so, there is a pending challenge to the Minnesota law in district court, saying, and it argues that this statute is preempted by the National Labor Relations Act, right? And the reason for that is that the statute's definition of political matters includes labor organizing, right? So it's not only about labor organizing, but it is partially about labor organizing. So that's definitely an issue that I am meaning to watch closely. At this point, there are, I think 4 or 5 of those statutes. I think Oregon's is the kind of longest standing. There was a case about whether Oregon statute was lawful that ended up getting dismissed on grounds other than substantive grounds, and it hasn't been challenged since then, I think because it hasn't been applied, but question whether there will be more sort of appetite to for courts to decide on the merits the case here, right, or sort of a case involving one of the other relatively new statutes. So that's kind of on my radar.
How do you anticipate that going potentially? Is it up in the air or?
Yeah, so I mean, on one hand, there have been kind of various cases where employers have argued that minimum labor standards ought to be preempted by the NLRA, and sort of, they say, look, this is the kind of thing that can be obtained through collective bargaining. And it will also sometimes be the case that, unions or the labor movement was seeking the improvement in minimum employment standards. And in those cases, courts have said, look, minimum labor standards are up to states. States can establish, various kinds of minimum labor standards, and they're not preempted by the NLRA, even if, unions have kind of been involved in pushing for them, or they affect positions in collective bargaining. Like, that's all fine. So the argument is that this is the same idea, right? That this is really about just sort of establishing a kind of like baseline across the board sort of scope for employee kind of freedom to be free from religious and political messages at work. I think the employers will argue, this is just secretly only about captive audience sort of union related meetings. And so one question, I think, is like whether a court believes that that's true, or whether the court believes that it's actually like this more general statute.
Mm-hmm. Well, I think we're at time now. So I just want to thank both of you for this really enlightening, engaging conversation.